What happens if you are partially at fault for the personal injury that you've suffered? Under Pennsylvania law, we have something called comparative negligence, which means that we can ask a judge or a jury at the end of a case to measure the degree to which you are at fault. So let's say you were going through a green light, you were turning right, you had the right of way, but at the key moment you looked down and started fiddling with the radio and a car came and turned left and ended up hitting you. It's their fault, but had you been paying attention, you could have avoided the accident. The defendant in that case can bring up comparative negligence. That means they can ask the judge or the jury to assign a percentage of the fault to you. So a jury can decide, you know what, we think you're 20% at fault. We think it's mostly their fault and you're 20% at fault. And that reduces your award generally by that amount. So if the jury awards you $100,000 and says you're 20% at fault, then you get $80,000 because we take 20% off. That's a very simplified version and it can get more complicated. Just because you're partially at fault for your injury doesn't mean you're not entitled to recovery. The circumstances and the facts can be really important. In general, if you are more than 50% in fault for an accident, you don't get anything under Pennsylvania law. Once again, this generalization, there can be exceptions. It's important if you've been injured to call a lawyer. This is a complicated thing and sometimes people feel like you can handle it on your own. It is more complicated maybe than it should be, so call a lawyer and talk to us at Cornerstone Law Firm. We'll be happy to help you and talk you through your options in your case.